Sorry.
We take those.
I got it. Thank you.
I'd just like to start with a little gratitude. I was very grateful that the judge took efforts to be sure that Robert was here for this very important hearing involving his state. Last time we were in this situation, we were completely shut out of this courthouse. There was no hearing at all.
How'd you get your phone?
But we're still not close to something resembling justice. The other bit of gratitude I'd like to express is for the people standing behind me. These are exonerees, people who gave up years of their life to the criminal justice system of Texas based on wrongful convictions, loss of due process. It's not a freak occurrence in the state. We've had 200 people in this country exonerated from death rows because they've subsequently been found innocent. But if you can't get the evidence to be considered by a court, how are you ever going to get a new trial? And that's all. We're not asking for Robert to walk out into the sunset. We're asking for a new trial. And I'm also grateful for you here today because I think the sun is shining. Not always the best thing in Texas, but the metaphoric sunshine of the public expressing concern that their systems are not working is so important. And I just ask you to stay with us. We're not going to stop fighting for Robert. He cannot give up hope. This is a man who suffers so much. And to think at the beginning of this story that it starts with losing a daughter he fought to have in his life. And because he, a man with autism and a 7th grade education, can't explain to the medical community her complex medical situation, he is condemned. He is suspected. They arrest the man based on this shaken baby syndrome diagnosis that has been completely discredited, even by those who still believe it's a thing. The version used to convict him is no longer accepted by anyone. That was the judgment made of him before there was even an autopsy. The autopsy happens the next morning with police officers in the room telling the medical examiner he's already been arrested for capital murder. How fair do you think that autopsy was? How can it be that so many highly qualified medical experts who looked at the evidence do not support the findings of that autopsy, and yet we're still where we are today? So I'm sorry for making a speech. I'm a little upset, but I am grateful. They're the inspiration that you can endure hell on earth and still keep yourself upright. That's what you gotta hope for Robert, for me. Thank you. And I will take maybe 2 questions, and then I can get my computer started. What happens next? As I mentioned, under state law, you have a right to withdraw an execution date under exacting conditions. I don't know how successful that would be, but we will also move for a stay. Since the CCA is already considering the case, there should not be this pressure on it to rush to the end of the story because now there's an execution. So there are at least those, but I will say there is a lot more that is wrong, and if we cannot get the Texas judiciary to honor this very important Texas law that got us a lot of accolades around the world. And I'm talking about that Article 11073 that has been mentioned a lot around this case. If Texas courts can honor that, there has to be a way to get some consideration on the federal level. So there is by no means are we giving up, but this does unduly elevate the stakes and make it just much more traumatic for everyone.
Well, you talked about we didn't have great audio in there, but you were talking about because there is a date now, his situation changes. Can you go back over just briefly?
Yes, once you have an execution date, the
I'm
clock
sorry.
starts ticking on things like the ability to apply for executive clemency. there's an obligation on the district clerk here to issue an execution warrant, which then goes to the prison system, which then triggers all kinds of obligations within the prison system about how to treat Robert going forward and how to prepare for this potential execution of an innocent man. And I will tell you, TDCJ knows this man is not a risk to anyone. As I mentioned in the courtroom, he is now part of this pilot program where he spends much of his day out of solitary confinement with other inmates, unshackled. And even before he was chosen as one of the first 12, part of the program, they allowed him to be unshackled in the chapel, praying with lawmakers. That was a message to the public. This man is not a threat. They do not receive a man capable of the kind of violence he has. When you're asking officials in the state of Texas to participate in what is potentially a murder, the one that you mean to have access? Access is very, very limited for lawyers when their clients are on death row as it is. You have to schedule phone calls. For instance, I tried to get a phone call so that I could talk to my client after today. The soonest date they could give me was July 30th. Well, by then I'll already be there to see him, which is also something you have to arrange. So it doesn't get easier. It certainly gets harder, and then all of the other things that he has to worry about, preparing for this potentiality, which that's not really something I'm very good at. I'm the fighter. I'm not the comforter. And luckily he has some beautiful people in his life who are his spiritual advisors, some of whom are here today. And I'm begging them to be there for him in every way possible.
We will.
You mentioned that there were a lot of, you appreciated the effort of my teachers in here, and you asked that bring in regards to
Sir.
I have never seen that kind of hardware. I've had many hearings throughout the state with my clients who are on death row, and it is quite common for a judge to use his authority to authorize they be unshackled so they can take notes. Certainly this would never have been allowed in front of a jury, but some of that I didn't even know what they put on him. They had like some terrible metal box so he couldn't even sit upright. He was in a lot of pain, he told me. That's the only thing I got to exchange with him, that he was having some pain. Robert is so humble. He doesn't do a lot of complaining, but I'm sure it was a pretty traumatic drive for him to have that on him all for the 2.5 hour drive.
Thank you for making that happen, though, whatever.
Well, and that we owe the judge thanks to that. I asked for a bench warrant. That's the language that when you want someone brought from a prison to a court, it happens all day, every day, courts across the land. But I asked, and I wasn't sure if my request was going to be honored. I actually found out, thanks to a journalist last night, that the order had been entered, and I thought it was very respectful of the judge to wait until the transport crew got here so that Robert could be present for the whole thing. That was a little gift of human dignity. We have to be grateful for that. But the excess, and I'm sure that had something to do with slowing down the trip.
what happens now?
Sorry.
You had talked earlier about how, you talked about how the city black. Now we've got to talk about how that the ball rolling. Would justice serve here in that regard when it comes to that, or getting the ball rolling, or
I don't know how setting a date gets the ball rolling. I will tell you the only time I've heard that phrase is referred to as cases that have been lying dormant for years and years. And back in the day when Texas used to set execution dates when people didn't have lawyers, they would use that word to get the ball rolling. And often, yes, setting an execution date would be finally, someone who has a lawyer and gets a lawyer. Not ideal. The idea that where a lengthy appeal is there were evidence that a child's skull had been bashed in, would we be here? Would we be talking about Joe Simon? That is a bald-faced lie. And I think this juror is not making this stuff up. I think he's been fed this. And unfortunately, I've seen this coming from some officials. False information about this case, about the state's own evidence, about this not being a shaken baby case, and about Robert. It is disgusting. And it's not justice. You don't try people on social media based on what propaganda you can get out there to outrage people. What you do is you look at the physical evidence. And it is an insult not just to Robert and to our system, but to the memory of this child. This child who was very sick virtually her whole life, and the doctors missed her pneumonia. They gave her contraindicated medications. She stopped breathing in her sleep, and she gets diagnosed with shaken baby syndrome.
feel like a lot of the evidence that has been released as of late, and you can talk about the stuff that came out in the formal. Do you think that's being ignored as of today?
I can't speak to that. I know that when we filed in October, in the shadow of the looming execution date, it is unthinkable that the volume of evidence we'd submitted could have been thoroughly considered and vetted in that amount of time. And I know that the court's own decision said they did not consider the merits. So they relied on a procedural bar that I don't understand and was not explained in the decision. But certainly now, here we are with yet more new evidence since October. And they have taken their time. That should mean something. But now this added variable, the stress of an execution day, it makes no sense. It's not the law, and it's not.
Nikki's brother said that exact same thing about her little head, and that the nurse was crying. She had the shape of her little head, and you saw the back of her head. Can you clear that up for us?
I would very much like to, because the reason the nurse shaved her head was because they could not see anything wrong with this child, except that her lips had turned blue. And she was obviously unconscious. There was no blood. There was a tiny abrasion on her chin and a small bruise on the side of her face. They shaved her head looking for some other indication, and they found a single bump on the back of her head, which our experts have referred to as a goose egg. You've seen the cartoons. Someone hits their head, they get bump. That is the body reacting to an impact. But it was so minor, there wasn't even a hairline fracture. How do we know this? CAT scans were taken of Nikki's head soon after she was resuscitated. Those CAT scans were locked up in the basement of this courthouse for 15 years. The jury didn't see them. The jury never heard anything about the minor bump and the small amount of subdural bleeding associated with that. They heard massive brain injury from shaking. Now, what the medical examiner saw 2 days later, after massive intervention, was far more blood inside the head. The blood wasn't there when the CAT scans were taken, and there were no broken bones, no cuts, etc. You cannot bash in a skull and have no fractures, no blood. That the family, the other side of the family, is being fed that information is a serious problem. That is manipulating the pain, the other side of Nikki's family. But I also do take issue, and I'm sorry again if I'm preaching here, but the victim here is Nikki. She was a victim of so many things. She was a victim of her complex medical history not being understood. Poor child on Medicaid. She was somebody who was loved by two sides of the family after being essentially abandoned by her birth mother. The victim's family isn't only one side of the family. Robert's family is Nikki's family too. And I really think this has not been emphasized enough. Robert was granted custody of this child 2 months before she died. by agreement. Who would agree to let the father have full custody of a child if he thought there was anything wrong with this man? If he was anything interested? And if you look back at Robert's record, this is a man who never had any history of violence towards anybody, let alone a vulnerable child. He volunteered for paternity testing so he could be held responsible. How often does that happen? So I'm glad that there's a record of someone saying in public, because I've seen it on lots of social media, that people are saying things about what happened to this child that are verifiably false. And I'm talking about the state's own medical records, those CAT scans, Harvard-trained medical radiologist, who is the only one to look at those, saying one small bump, tissue swelling, small subdural bleed, no fractures. And of course, if this were a battery case, there would never have been a shaken baby diagnosis. That is the fundamental origin of this thing. It's an explanation for what seems inexplicable. But it's been falsified by the actual study of biomechanics, which looks at how does human injury happen. The biomechanical engineers have debunked this, and we're just not listening. DPAs historically, how long can you? I mean, there's no, before there was an execution date, the idea is the court should have breathing room and not have these external pressures. There are no deadlines, but now there is a deadline. Yes, I mean, the trauma of an execution date is never going to go negative.
What were they?
I don't know. I don't know how they will feel about having this external pressure. I don't think that's something that they would share with us as a member of the public. But if you just think about it, the difference between let us take the time to review the evidence and make an informed decision versus now we have 90 days. This is what you, when you, the state filed a motion, and the way that works, it goes back to the convicting court. So that's just standard practice. The only time an execution date gets set is by the judge in the convicting court. The judge who actually presided over this trial is no longer with us, and there was a new judge assigned who voluntarily recused herself in November. Judge Jackson was assigned apparently in February. Again, I wasn't served with notice of that, despite the order itself saying as soon as practical, notify the parties. I learned about what was it, a week or two ago that we had a judge. So this is another. There just has not been transparency around virtually anything about this case. And back to that question, one jury who wrote virtually nothing that has ever been developed since 2016, and what we have is procedural law getting in and reviewing the evidence. That is not the way we should handle the most serious of cases. All right, I've got to go. Thank you for being here.